For oral answer, I call on Government Order of the Day number 1.
Government Communications Security Bureau and related legislation amendment bill, second reading.
Mr Speaker.
Honourable Chris Finlayson.
Mr Speaker, I move that the Government Communications Security Bureau and related legislation amendment bill be now read a second time. Mr Speaker, there's been a great deal of scrutiny and debate over this legislation. There's been a lot of uninformed commentary, and there have been a number of examples of the great and the good, the well-meaning but impressionable, being misled by ill-founded fear-mongering. So at the outset, let me make it quite clear. This legislation is not a revolution in the way New Zealand conducts its intelligence operations and national security. It is not a case of expanding the borders of some intelligence empire. This is about fixing legislation that, at its best, is not fit for purpose and, at worst, is broken. Under this bill, New Zealanders can be confident that our intelligence agencies are acting in accordance with the rule of law. The bill sets out definitively what it is our intelligence agency can and cannot do under the law. There are no grey areas, there are no loopholes. This is very important because of the status of national security in a democratic society. National security is vital for maintaining the freedoms and the way of life that we hold dear. It's vital for keeping us safe and free from harm. But national security tools, if turned inwards and not subject to strict controls, can erode that way of life and threaten the freedom of individuals. National security legislation must not have loopholes that can be exploited by those who would threaten our security, who would threaten loss of life through terrorism or criminal activity. But equally, national security legislation must not have grey areas of uncertainty or doubtful interpretation that allow the state gradually to extend its activities and creep into ordinary people's private lives like some kind of growing shadow. Mr Speaker, the bill strikes the right balance. It makes amendments to 3 acts, with the 3 main objectives being to clarify what the GCSB can and cannot do, to update the legal framework in response to the changing security environment, and to strengthen the oversight of our intelligence agencies. Mr Speaker, Labour's 2003 Act sought to codify and make transparent existing practices of the then Government Communications Security Bureau. It failed. The Kitteridge report found that the 2003 legislation is not, and probably never was, fit for purpose. The Bureau currently has 3 core functions: cyber security and information assurance, foreign intelligence, and cooperation and assistance to other entities. Those 3 functions are retained under this legislation. For an organisation possessing the powers the GCSB does, an unclear legal framework is simply unacceptable. So the relationship between these 3 functions has been set out in much more explicit terms than in the existing legislation. Between 2003 and 2011, there were 88 instances of surveillance that highlighted difficulties of interpretation. There is a grey area in the current law, and it arises because of a lack of clarity over the legitimate activities of the GCSB of those 3 different functions. That grey area disappears under this legislation. On the matter of assistance and cooperation, Labour's 2003 Act said that the GCSB could assist other public agencies in New Zealand in the performance of their functions, and also to prevent and detect serious crime. It authorised explicitly the surveillance of foreign organisations and individuals to obtain foreign intelligence, organisations and individuals that in some cases may make contact with New Zealand citizens and residents. But the law also said, in apparent contradiction, that the GCSB must not intercept the communications of New Zealand citizens or permanent residents. In hindsight, sir, this was a recipe for confusion. Parliament had intended something straightforward, that the GCSB should only target foreign nationals when gathering intelligence under its second function, and in addition, it should also be available to assist agencies such as the police and the SIS in their legitimate, warranted domestic activities. But the wording was contradictory and unclear. The GCSB acted according to its internal advice to fill this grey area. Now, that advice was in keeping with the intention of those who passed the Act in 2003, but it may or may not have been justified by the words of the statute itself. Mr. Speaker, ambiguous law which leads to secluded decision-making on a case-by-case basis is unsatisfactory. So we're taking these steps to overhaul the legislation and make it fit for its original purpose. The responsible thing for this Parliament to do is to clarify the Act to specify which agencies the GCSB may assist and to what extent, and to remove ambiguity and increase oversight from outside the agency. The question of oversight is a very important one generally, not only in relation to the GCSB. Former GCSB Sir Bruce Ferguson recently implied he wished there had been greater oversight of orders he issued as head of the Defence Force, classifying some journalists as subversives. This week he acknowledged he'd never thought of journalists as the enemy and expressed his disappointment that no one had since overturned the orders he couldn't remember making. It's a reminder that memory can fail us. Some commentators, including Sir Bruce, have opined that the questions around the GCSB represent something new about the way intelligence operates in this country. Mr. Speaker, that is simply untrue. The problems of drafting and legislation and legislative interpretation date back to the passage of Helen Clark's 2003 legislation. This bill is not revolutionary. It's not an aggressive expansion of state powers. Its purpose is to provide concrete rules that leave less room for uncertainty. This is evident from the treatment of metadata in the bill. There's been much talk of metadata recently. It's become something of a buzzword. But there's no magic in metadata, I say to Mr. Peters. In this bill, metadata is treated as any other communication. This bill authorises the interception of certain communications. Communication does not differentiate between data and metadata. For the reason pointed out by a number of submitters, we do not have a clear definition of metadata. The type and number of ways in which data can be described and indexed, that is, the categories of metadata, are growing all the time. If we included a definition, then we would risk leaving loopholes as the new technologies emerge or new business systems are developed. Mr. Speaker, we don't want loopholes which expose New Zealanders to unnecessary risks because our legislation cannot keep up with technology. Nor do we want amorphous gaps in the legislation which could allow agencies to exceed the powers intended for them by incrementally extending definitions by analogy. Mr. Speaker, this bill takes into account national security and privacy. The issue is not national security or privacy, it's both. National security is about protecting our citizens and the rights and the freedoms we value. The legislation is sensitive to those rights and freedoms. Mr. Speaker, in conclusion, the bill has been subject to extensive discussion and debate which on occasion has obscured this very important issue. As the bill before us today incorporates 19 recommendations endorsed by the Intelligence and Security Committee, and it's important to say they reflect public submissions, and there will be further changes which have been flagged publicly in a supplementary order paper. Mr. Speaker, as I say, this bill does not represent an extension of powers but a clarification. I commend the bill to the House.
The question is that the motion be agreed to.
Thank you, Mr. Speaker.
I call the honourable member
Mr. Speaker,
David
Labour
Shearer.
opposes this bill, and we oppose it not